let's do a little review. So last week we did Maya Pierce, Prince, and Yoder, and we really didn't get into Troxel, but we can use Troxel also for this discussion. So I put on the board sort of the three sides of the triangle: parent, the child, the state. Okay, the red was working really good a moment ago. Parents' rights, think of it as sort of protection from state interference. Child, which we haven't gotten into this yet, but you had to read golf for today, same due process rights as adults. And then the state's right, protection from undesirable parental conduct. So if we go all the way back to Meyer, where are we putting Meyer here, Jonathan?
I'm not even sure. I read Galt for today.
No, last week's cases.
Oh.
So we're doing a little review. Where should I put Meyer, Stephanie?
I don't remember the name, but I remember the cases. Myers would have been...
What was the holding in Meyer? Anybody remember? Amanda?
That was for the child.
I'm sorry, go ahead. What?
It was in favor of the plaintiff,
If you had to put in one sentence, what's the proposition? Think of it for a second. And Meyer was the very first case you read last week. What's the proposition for which Meyer stands? You had to put it in a...
It was, well, it sort of throws it off a little bit because it wasn't exactly the parent, it was sort of the teacher.
I know, but then it sort of mushroomed into this court. Remember, we talked about the specific holding. Yes, the parties were the teacher and the state,
right.
But in terms of a parental children's rights case or a victory for the state, where would you put Meyer?
I would say the parent.
The parent. Yep. And what do I mean in the context of Meyer when I say parental rights means protection from state interference? It was the parent's right to do what, Stephanie?
She could choose. The parent could choose.
Choose what?
Choose.
The right to have...
The right to have...
The child
educated.
More specifically, in a certain way, right? Instructed in the German language, something like that, right? Right to, I'll just say right to German language. You guys know what I mean, right? And we're talking about substantive due process rights of the family, right? That was 14th Amendment, substantive due process right of the parents in Maya v. Nebraska. The next case that we had read was the Pierce case, right? Where does that sort of belong here in terms of parental right, children's rights, states' rights? John? Oh, I'm sorry. Yeah. I forgot your name. Michael, right?
Yeah.
Yeah.
That was also under the parent, the right of choosing public education or private education.
So the parent's right to the private schooling, right? Right? 14th Amendment again. And then the next case you had was Prince. And that was a little bit different twist, right?
That'd be
John?
That'd be under child, right? Because it protects the kids.
What was the holding of Prince?
That the issue is whether mass child labor laws violate the 14th Amendment, and it was held no. Prince's conviction was affirmed. So it protects the kids from being worked underage.
Did the court specifically talk about children's rights in its rationale in deciding for the state of Massachusetts?
It's just labor laws in general, I guess. but they did talk about, yeah, you can't be a guy or a boy that's, 12 and a girl that's 16.
You can't be what?
I thought that case went over the statute that said boys that were 12 and girls that were 16 can't be put to work.
And whose duty or responsibility did that fall within?
The state.
That was the state.
The state.
So that was
The state. Protection from undesirable parental conduct. And you just started the quote, John, when you started to say, right, parents are free to be martyrs themselves, but the state has the duty to protect children, in this case, from, being out on the street at night, etc., right? And even though, let's see, so Prince, state protects free, we'll say child labor, like that, right? Even though Sarah Prince what was the nature of Sarah Prince's right that was different from the parents in Meyer, the parents in Pierce?
Well, with Meyer and Pierce exercising their rights to teaching in a certain language or going to a private school, the child wasn't in any danger, but...
That's the distinction, okay? But before you even get to that point...
hers was a First Amendment right?
Yes, so Sarah Prince, First Amendment plus 14th Amendment right. So I, as a parent, have the right, life, liberty, property, have the liberty right to bring up my children the way I please without state interference. And the state can only interfere, going back to Meyer and Pierce in terms of the test, the state can only interfere if there's a rational relationship to the statute. So it's kind of easy for the state to interfere, even though the state lost in Meyer and Pierce. But when the parent asserts not only 14th Amendment right to bring up the children in the way that they want, but also a right of religion that makes it, again, more difficult for the state to overcome and having to show a compelling interest for the interference. And the compelling interest, as I think either Mike or John just said, was child welfare. Dangerous for the child to be out on the streets, etc. So there we have it. So Meyer, Pierce, Prince, and where does Yoder fall here? Is it a parental rights case, children's rights case, states' rights case? Amanda?
Yoder is for the children.
Really?
I think it kind of falls in between the parent and the child, because part of the considerations were that some high school age Amish students may not wish to, didn't they talk about if they didn't want to?
Remember when we started first class, we talked about that in the older cases where children didn't have a direct voice, that children's rights were more about the state asserting what it thought was best for its citizens versus the family, the parents asserting what it thought was best without the child or the children having any direct voice. So therefore the majority holding of Yoder is for the
Parent.
for the parent. But at the end of last class, we started getting into the dissent. But Yoder, the parents who were Amish, as opposed to Jehovah Parented Prince, had the same, were asserting the same sorts of rights, right? 14th Amendment right. I know what's best. I can take them out past the 8th grade. In addition to that, it's also my religion to do that, and I have the right to have my kids practice the same religion as me. Yoder. Okay. But what did Douglas say? And now we start to come to court's beginning to recognize that we need to hear from the children too. So that's where, I think that's where we ended with the Yoder dissent.
Right, because he was
So-
saying the children should have a voice.
Yes. So even though it's really, a dissent and not part of the law, we'll just stick it here for now. The Yoder dissent, Douglas's assertion that, quote, I think the children should be entitled to be heard. And remember, he specifically referred to, some of the kids that hadn't testified and talked about perhaps at least being able to hear from the children relative to what they want. It doesn't necessarily mean that the court would agree with that, but the children should be entitled to some sort of voice. Okay. And what about Truxell v. Granville? Parent again. And Jim, what was that case in terms of its holding?
That Granville had the right to basically.
Who sued who in that case?
Granville actually ended up suing the grandparents.
Yeah, so Granville was the mom, the Truxells were the grandparents.
Tommy Granville, the mother, and Brad Truxell shared a relationship, and they had 2 children, and he committed suicide. And
Right.
at the time, she was allowing the grandparents to have visitation.
Some kind of visitation.
Some type of visitation.
Yeah.
And even when she brought it into court, she didn't say that they could not have any visitation.
So what was the statute under which the Truxells were suing her, and ultimately the statute that the U.S. Supreme Court found to be unconstitutional?
Let's see.
What was wrong with the statute that interfered with her parental right?
It never gave her any special weight on her, what was in the best interest of her own daughter.
Who determined best interest under the statute?
The state did.
The state meaning the court, the judge?
Yes.
The trial court judge?
Right.
So what was wrong with that? With the judge doing that, versus the...
I think what the Supreme Court said, that was a violation of 14, in that it was the right of the parent to be able to make that decision, not the trial court judge.
Joe, you had your hand up a moment ago, too.
Well, yeah,
By the way, just, I don't have, I have everybody's email in the class, I think, except yours.
Yeah.
And that's going to be important because I had emailed, and I want to leave time to talk about what we're going to do on Thursday, the mock hearing. So make sure you email me.
I'll do it.
Okay, all right, go ahead.
no, I was going to say that I think the problem with the section was that any person could petition the court and for visitation rights at any time. So let's say that the parent had a problem with a certain person having visitation rights. That's completely out of their hands. It puts it completely in the court's hands, and therefore their parental rights are being interfered with.
And what did the court say about this mom or any mom or dad under the statute being a fit parent or not, Laura? Do you remember?
That it didn't take into account whether they were fit or not, and in this case, she was fit.
Mhm.
And no one had ever claimed that she wasn't a fit parent.
Why is that important?
Because
If she is fit, and what does that mean in terms of somebody else, say grandparents having visitation?
that she should, as a fit parent, she should be able to, rule's not the right word, but on the best interest of her child.
Have some voice, have some say. Later on, when we get into the camp protection cases in Massachusetts, where the state, does interfere and is looking for custody when parents have allegedly neglected or abused their children, the issue in those cases is fitness. And we'll deal with, for example, when DCF does have, the Department of Children and Families has custody, as a parent, because even though it's an agency, the agency has now become the parents patriae, does have the right to control one of the things, visitation. And then in Massachusetts, visitation actually cannot be suspended on behalf of a parent unless there's, a potential of parental harm. But anyway, so these cases are the precursors. They're the basis for your involvement as an advocate in the juvenile system. It's about parental rights versus the state. It's about children having a voice as well. And these are just a few of them, but they happen to be the landmark cases that stand for substantive due process in the parental versus state area. With Galt, we get to something a little bit different. We start to hear not only directly from a child, but it's a case concerning the child as a party, and where these cases were all substantive due process, we now get into procedural due process. So let's go through Galt in a little different way, almost like a case briefing this time. Someone give me the facts procedurally, starting from when Jerry first got into trouble. Who wants to start? Who had their hand first? Either one? Who wants to go first? Okay, Jim, go ahead.
I'm trying to make up for the other day for
Okay.
my flu. Jerry Galt was 15 years old. He was accused of making obscene phone calls to a neighbor, Mrs. Clark. There was also another boy. And his friend Ronald Lewis. They were both subsequently taken, or considered taken into
Okay,
custody.
so let's go step by step here. Before you get to that he was accused, what's the first thing that happens sort of procedurally? Or we can look at it a different way. Begin to tell the story, right? So Jerry's home from school for one reason or another with Ronald, right? Okay.
And there's a question about whether, he picked up the phone. There was a question about whether he dialed the phone, but there was a question about whether who actually made the obscene.
So they're home and they're doing allegedly something, right? At the conclusion of the school day, where is Jerry? Laura, where's Jerry and Ron?
At Jerry's parents' home.
Are you sure?
At the start of the school day?
No, at the end of when they get picked up by, who are the players here? There's two officers, Flagg and Henderson, right?
Yeah.
Okay. So where are they when they get picked up? Do they get picked up together?
Sorry, I thought they were taken from the home.
Whose home?
The Galt's home.
The Galt home. So Jerry and Ron are by themselves at the Galt home?
I thought so.
Are we sure?
Yeah, both parents were.
Parents were at work.
Because the parents weren't home, right? Okay. Who knows that they get picked up?
No one.
No one.
Are you sure? Jonathan, right, one at a time.
The complaint, I forgot her name, but the neighbor knew that they got picked up. But
Who's the neighbor?
Miss Clark, is it?
Lewis.
Or Lewis, the one who got the phone, or who made the complaint in the first place.
No, somebody, no, because, okay. So you're Mrs. Galt, Laura.
Okay.
You come home and Jerry's not there, right?
Right. So then
Go ahead.
I asked my older son, has he seen him? Does he have any idea where he is?
Yeah.
And my older son goes to the Lewis's trailer home, and they somehow know where the boys.
So they knew, and I forget at which house they got picked up. They were initially at Jerry's house, but it was Ron who also got picked up, and they knew where the kids were. Okay. So then what did Jerry's parents do next?
So then the father wasn't there, but the mother and the older boy went to the detention home where he was taken. And
When they go there, what transpires?
so she was orally told that there was a hearing the next
By
day.
whom?
The probation officer.
Which one was that?
I don't have his name.
Officer Flag.
Flag.
So Flag says, you can't see him now, come back tomorrow. We're gonna, you can show up at the court, right?
Yeah, they'll be hearing tomorrow.
Okay.
Nothing had been served on the Galts, no petition, and when they did see the petition, there were no factual
So wait,
basis.
stop. So they leave, she leaves crying, my kid, Mom. Goes next day, so who's at court and what's the scene
So the-
like?
it's in the judge's chambers,
Yeah? Yeah.
and the Mrs. Cook, who was the one who had the allegation, she wasn't there. No one's sworn in, there's no transcript or recording, and Gerald was questioned by the judge.
Okay. Michael, what does the judge say to Gerald? From what we know, because obviously this is the
Well, they talked about the remarks, and the judge claimed that there was some reference to that Jerry had made the phone call, but that he hadn't necessarily made the worst remarks. And I think he also talked about his history in the past, like that he had
so either
troubled past.
was it Stephanie, either Flag or Henderson, which one of them had the priors, knew about Gerald's probation history?
One of them said that he was delinquent, which I believe was Henderson.
For having done what before?
A baseball glove. He stole a baseball glove.
Something to do with a baseball club?
Yeah,
Okay.
I think he stole a friend's baseball glove.
Okay, okay. So we're still at sort of that first Judge Chambers hearing, right? So what happens at the conclusion of that? Yeah.
Well, there was also a discrepancy in what transpired at the hearing as far as what.
Yeah, so when the appellate courts later looked at that, Judge said certain things, and Flag and Henderson said certain things, and Jerry said certain things. Go ahead.
So Mr. Recall, his mother stated that he had only dialed the number. That's what he had said at the hearing.
Mm-hmm.
And Officer Flag agreed at the hearing that he did not admit making any of those statements or those remarks over the telephone. And the judge recalled that there was some admissions. So there was a conflict about the testimony itself, which was not recorded or documented.
And by the way, Laura said that at that point in time, neither parents nor Jerry had received any form of notice. Did they know what he was charged with at some point?
Not
I
till.
don't think until they got there, until they got to the hearing.
No.
It says they weren't given a formal.
So what were they told? What was the reason why he was being held, and what was the reason for his arrest?
He was delinquent.
Delinquent in having done what?
Well, initially
What was the criminal conduct that Jerry and allegedly Jerry and Ronald engaged
I think
in?
it was stated in the initial.
Did they say a lewd phone call?
A lewd, obscene phone call, which was a violation of some Arizona state statute, right? Okay. So at some point they, get notice of that's the reason for him having been taken in, correct? And Laura had
formal
mentioned.
notice.
What's that?
Not formal notice, not
Right.
formal notice.
Right. And Laura had mentioned that at the Judge Chambers /hearing, there was talk of Mrs. Cook at that point, correct?
Right, but she was not there.
Okay. And then later on, when the hearing happened, who was at that hearing? The hearing in which Jerry was actually then found delinquent and sent to
To the institution.
To the institution, I'm sorry. Yeah.
Jerry, both of his parents, the other kid, Lewis, his father, and Flagg and Henderson were there before the judge.
Yeah, yeah. So what kind of evidence does the court hear at that point?
Here's
On the hearsay.
hearsay.
So in the form of what? Who says what?
Well, the officers pretty much dictate the complaint in court. So, but the person who actually formally made the complaint, I forgot her name, wasn't there. So I guess it's a Sixth Amendment issue.
Yeah, we'll get to what his rights were and what the court considered, but I just want to make sure everybody, take you through sort of all the scenes here. So at the conclusion of that hearing, in which we hear from Flagg and Henderson, as Jonathan just said, what Mrs. Cook had told them, right? Then Jerry gets committed. So how does the appeal process then start? Yep.
On August 3rd, 1964, the petition for the habeas corpus was filed with the Supreme Court of Arizona.
Yep.
It was referred to by the Superior Court.
Yep.
And then they had a hearing on the habeas where the judge who sat on the original delinquency case was...
I'm sorry, say that again?
At the habeas corpus hearing, the judge that sat on the delinquency hearing was cross-examined as to the basis of his action system.
Yep.
And he basically explained why he sentenced him the way that he did, that he took into account his probation, and he was asked specifically about what section of the code he was using to determine the boy's delinquency.
Okay.
Out of their RSA, it's 8-201. He used it as specified what a delinquent child is. It says one who includes one who has violated a law of the state or an ordinance or regulation of a political subdivision thereof. He said the law which Gerald was found to have violated was Arizona Revised Statutes 13-377.
And so what does the Supreme Court of Arizona hold and find and rationalize?
Well, the Superior Court dismissed the writ, and then they sought the review to the Arizona Supreme Court.
Yeah, that's what I'm asking. What did the Supreme Court of Arizona find?
I mean, it was an elaborate and widespread opinion affirming the dismissal.
Affirming the dismissal of Jerry's writ of habeas corpus. And then the case goes to the Supreme Court, right? Okay, so everybody understands the procedure here. Now, Jerry makes an argument based on 6 rights, and we'll go through them in a moment, but bear in mind, and people always get confused about that, the Supreme Court doesn't decide on all of them. Okay? So what's the first right that the Supreme Court goes through? And Laura mentioned it at the very beginning.
Notice of trial.
Notice. Let's put golf here and the child. And number 1, notice. What does the court say about notice in juvenile proceedings? And by the way, I said at the beginning that we're talking about procedural due process. And it's like a 2-part test. We're still talking about, either life, liberty, or property. But if you, represent someone where you're going to be arguing procedural due process, number 1, first you have to examine those rights. And the first question is process due? Does my client have any due process rights? And then if the answer to that is yes, then what process is due is going to depend on, going back to number 1, the nature of the right. Okay? So in terms of Jerry's life, liberty, or property right, what are we talking about?
Liberty.
Liberty. But, you know, we say it so easily, but back then, when the, you know, juvenile courts first started, and by the way, there's a nice, you know, sort of summary of the historical precedent of juvenile courts here by the majority and by the dissent as well in Galt, that the notion originally was that, you know, children by themselves really didn't have liberty rights. That, again, it fell back to the parent's rights to custody and the parent's right to do what he or she felt was best. And that children, because they weren't, you know, jailed in adult prisons, really didn't have any due process rights. That the, you know, mission of the juvenile courts was to rehabilitate in, you know, fatherly, parents patriae types of courts. So when the Supreme Court decided this case, it was, and still is, a leading case that stood for the proposition that if you're going to take a child and place that child in a place where they can't leave, basically DYS, facilities, you know, like in Arizona at that time, then there, not only was their liberty right implicated, but it was a really fundamental, basic right, so that the process that's due is the same process that would be due to an adult. So you're talking about, at least for this type of case and these kinds of proceedings, that juveniles are afforded the same due process rights as adults. All right, so let's get back to notice. So what does the Supreme Court say about notice, Laura?
Because the child was being denied of his liberty and the parents of their custody, there needs to be advance notice. Well, there needs to be notice of his being taken into custody and advance notice of hearings.
Yeah. And notice that not only does the child get notice, but the parents get notice as well, because the parents have custody of the child. And you still see that today. We'll see that in the when we go through the delinquency proceedings, the camp protection proceedings, the CHINS proceedings later on. And they've got to get the notice ahead of time. All right. So before, you know, when obviously Jerry might have been arrested while, you know, parents were at work, but it shouldn't have happened the way that it did. That Jerry's mom and brother, when they went running, they had no idea. They didn't know specifically what he was charged with, etc. So notice with specificity in writing, etc., ahead of time. Later on, when we examine, for example, students' rights. For example, you can say to a kid, if you're the principal or vice principal or whatever, you're suspended, go home. Okay. Well, you've got some right there in terms of education, but it's not the same basic fundamental liberty right that, for example, that's similar to Jerry Galt. So the notice is you're going home. We're not going to give, you know, you could talk to me, right? You can have a limited sort of opportunity to be heard, but you're going home for the week or whatever. And you could take that further after the fact and come in with counsel, etc. So, you know, the rights are not as fundamental, because the school child has some kind of right to be in school, but it's very different from Jerry's right, which again, he'll be put in a place that he can't leave. So he needs to get that notice ahead of time to prepare. Michael?
Now, that notice only kicks in when it's something that is going to threaten their liberty. So if it were just, say, like a loitering statute, and he was just going to get like a $50 fine, you don't necessarily have to provide notice to the parents of the $50 fine. It's only if you're going to...
You do, because it goes to the criminal violation. So, for example, when we do look at the delinquency cases, you're actually, like Jerry did, you're charged with delinquency by reason of having violated
I just
a
meant,
statute or an ordinance.
say it was the first time he ever got in trouble, and so he wasn't, you know.
That's true, but when you look at the cases, the court, the judge, has the discretion. There's no like mandatory minimum, et cetera. There is, you know, later on when you get to murder and other cases like that, but has the discretion to perhaps sentence to DYF. So their liberty is still potentially at stake, but good question. So again, Jerry raised that as one of his arguments on appeal. The Supreme Court bought it. After this, notice, you know, if you're going to charge a kid criminally, and I remember the Supreme Court is the law of the land, so states have to follow, you know, minimum, could give more. So from that day forward, if a state was going to charge a child with some kind of crime, both the child and the parents had to get notice in advance, again with specificity. What's the next right, Amanda?
Right to counsel.
Counsel. Right to counsel. Somebody talk to me about that. Why did the lower court say, what was the rationale for both, you know, the Superior Court and then the Supreme Court of Arizona? What was their argument and the state's argument relative to, hey, kids don't need a separate attorney. We've got enough in the system. What was their argument about? Joe?
Didn't they say that the courts had the discretion and not the duty to provide counsel?
Yeah, that was one of the reasons. Amanda?
Because the probation officer wasn't acting on behalf of the child.
Yeah, they say, you know, why do you need a separate, you know, attorney for? Probation officer is there to say what he or she thought was best. Laura?
They also said it wasn't an adversarial process.
Yes, wasn't adversarial, and you'll see that a lot in terms of arguments that advocates on either side sometimes make. It's not adversarial like an adult process. What do you need an attorney for? When you get an attorney in there, then there's going to be, you know, all of this bad fighting happening, right? Yeah. So what does the Supreme Court say? John.
They said that because the parents weren't, or the family in general wasn't given, weren't aware or weren't made aware of their right to counsel, and because there was no active waiver.
When you say there, be careful, right?
Or the child's right.
Right.
Right to counsel. They weren't made aware of it, and there was no outright waiver of it that right was infringed upon when they continued on with the process.
In light of what I just said earlier with the notice, Supreme Court says here relative to right to counsel, the same argument, a proceeding where the issue is whether the child will be found delinquent and subject to the loss of his liberty for years is comparable in seriousness to a felony prosecution. The child requires the guiding hand of counsel, quote, at every step in the proceedings. So this became, you know, one of the first cases decided in the late 60s, you know, constitutional era in terms of rights of the child. So right to counsel in specific proceedings, however, the court talks about in the adjudicatory phase of a delinquency proceeding. Do you know what that means? The child has right to counsel in the
guilt phase, like the trial part of whether...
Exactly, the trial part. However, Galt has sort of mushroomed into children having counsel in other areas. Again, when we get into, you know, for example, a child abuse proceeding, where really child hasn't done anything, parents have either allegedly abused or neglected the child. But not only in Massachusetts, but all of the other states, children have right to counsel. Is it the same sort of liberty right as Jerry Galt? No. But as a result sometimes of those proceedings, children are taken out of the home and placed in foster homes. So, you know, the analogous argument has been made that we're going to extend what was decided by the Supreme Court in Galt in terms of right to counsel in other kinds of cases as well. So, right to counsel. What other rights did Jerry argue about? Right, I'm sorry, notice, right to counsel,
Confrontation with Ms. Cook.
confrontation and cross-examination, right? And of course, that had to do with the lack of presence of Mrs. Cook, correct?
Yeah, and in fact, they actually requested her to be at the, when she was in chambers, and the judge said, you know, that's not
She doesn't need to
necessary.
be
She doesn't
here.
need to be
Right, she
here.
doesn't, you know, because we know what's best for Jerry, and Flagg and Henderson have told me everything I need to know, right? And again, getting to the lack of, you know, adversarialness supposedly of these proceedings. And the Supreme Court says no. Because again, getting back to the nature of Jerry's right, he's got the right as a child faced with delinquency proceedings in which he could use his liberty to confront his accuser, to cross-examine her, to have the court, you know, gauge her demeanor, decide whether she's lying or telling the truth, etc. So confrontation and cross-examination. And then lastly, what's the last one?
Review and transcripts.
No, there's one before that. Hold that thought, because he did argue those. John?
Self-incrimination.
Self-incrimination. So when the judge first talked to Jerry in chambers, nobody said to Jerry, you don't have to
Same.
talk. And then, and by virtue, because of that, there were all these stories about what Jerry said originally, etc. Now, in fact, the burden of proof, because it's a criminal proceeding, like an adult proceeding, is beyond a reasonable doubt, and the burden of proof is on the state. You don't have to do anything as the defense. So those were the four important rights. Amanda just mentioned two, which the court didn't decide, which were
Appellate review and transcript.
appellate review and the transcript. Not a part of the majority ruling of the court, even though Jerry had brought them up as issues and legitimate, you know, issues and arguments. But these are the four rights for which Galt stands today.
It always kills me how they do that. Like, oh, we don't really have to address these because this already overturns it, so we'll leave those for another day.
Exactly, exactly.
Come on, leave the world in the dark until some other case happens.
And we do get this, by the way, in our state, especially in cases like this, where you have the right to appeal, and consequently you have the right to formal transcripts on appeal so that you can make your appellate arguments. Jim?
Professor, just as a caveat to the right to counsel, did they not address the fact that they addressed her right as well, the parent's right to be notified of counsel?
No, the parent's right to notice of the charges. The parent's right to notice.
I'm just reading under the habeas, they addressed the habeas corpus proceeding where Mrs. Galt testified that she knew that she could have appeared with counsel at the juvenile hearing. And then they said this knowledge is not a
With counsel for Jerry. Now remember, so, you know, you run across sort of tricky issues in some of the cases later on. For example, in what used to be called CHINS, Children in Need of Services in Massachusetts, and is now called Child Requiring Assistance. What happens is, by statute in Massachusetts, the children always got counsel, And yeah, so say you're an attorney, Laura, and you've been appointed to represent, 12-year-old Haley, who's the reason for the Chin's petition being issued is because Haley is disobeying her mother, parent. Well, Mom wants to talk to you and tell you all about Haley's disobedience and wants you to sort of advocate, for what the parent wants. And that can get tricky because you represent Haley. You know what I'm saying here?
Yeah.
The Supreme Judicial Court decided some years back that in cases like that, where it looks like the child might be pulled out of the home as a result of their behavior, that DCF may get custody, that parents actually could get attorneys in that case. But in the delinquency, in cases where the child is before the court because the child has committed a criminal offense, even though the child's in the custody of the parent, right? Only it's the child that gets counsel. And then, I'm sorry, go ahead.
Maybe
you have a question?
I didn't, I'm misinterpreting it, but.
That's okay.
I think
That's
what
okay.
I was trying to address is not whether she was entitled to counsel, whether they had a right to expressly be advised.
That the child could get counsel.
Because they don't say he, they said they had a right to be expressly advised that they might retain counsel and to be confronted with the need for specific considerations of whether they did or did not choose to waive the right. If they were unable to afford to employ counsel, they were entitled in view of the seriousness of the charge.
Yeah, and you know what? That also brings up, so for example, the children being able to waive certain rights. So we'll get into that later on. For example, a child can certainly waive right to counsel, but the court has to be satisfied that that waiver of right to counsel, no, I'm going to go by myself, I'm going to do the admission, I'm 12. Well, the court has to be satisfied that, your waiver is sort of a knowing, intelligent waiver. And the waiver of counsel might be, co-signed by parent, for example. And or the juvenile court judge might examine the child orally to make sure that the child understood, and with parent there, of course, because how is the child even going to court unless the child is being held? Parent is bringing the child to court. And again, until the child is committed to an agency like DYS, the parent has custody. So the parent is directed, even though we talk about the same due process rights as adults, it's still within the context of the child being within parental custody and having parental involvement. I've seen judges in juvenile court actually, issue like summons and sometimes, worse than that, for parents not showing up, with their children for these proceedings. I just want to check the time. Okay, good. It's almost 2 o'clock. Let's choose our roles. No, everybody got the email except Joe? So, okay. So what I did was I sent out the exercise we're going to do on Thursday. And what we're going to do is two sort of, actually maybe three, if we have time or not for the third, hearings. The first being something, almost a reenactment of what occurred in Judge McGee's chambers. Before, and notice it said first hearing before Supreme Court case. And for that hearing, I actually don't need all of you. We need 1, 2, 3, 4, 5. We need 7 people to play some of these roles. So I'll go with volunteers first. Who wants to be Jerry Galt? Jennifer? Okay. Who wants to be Mrs. Galt? Laura? Jerry's older brother? Joe?
Sure.
Officer Flagg? Jim? Officer Henderson? Officer Stephanie? Judge McGee? All right, I'll be Judge McGee, all right? How about my clerk? Okay, Jonathan. Okay. Now, we need more players because for the hear, so we're gonna conduct then, and when I say second and third hearings, what I'd like to do is first like a quick, so for example, the analogous hearing to that first hearing in Judge McGee's chamber where Jerry's first brought in, and should be, notice of the charges, question of plea, question of bail, things like that is what's called an arraignment today, right? So the defendant coming into court for the first time. So that'll be a quickie one, but that second page that I gave you guys is really what I want to get into, and that would be part of the actual trial, where the witness for the Commonwealth is Mrs. Cook. So I need a bunch of players anyway for those hearings. So let's have a different Jerry Golf this time. John? Okay. Mrs. Golf?
Do you want the same one or do you want a different one?
Let's do different. Amanda? Mr. Golf? Joe? Okay. Officer Flagg, Jim? You had your hand up for the other one.
It's okay that I'm him in the first one.
Oh, you were? Okay, no.
I don't mind.
I'll do it.
Okay. We'll have Michael as Officer Flagg. Officer Henderson? Okay, Jim. And then I'll be the judge again. Attorney for Jerry? And actually, let's double up on this one if we can. I know Amanda's missing. Is anybody else missing besides Amanda?
Nicole.
Amanda and Nicole are missing, so I'm going to give them roles too. Jonathan, did I see your hand go up?
Oh, I thought you were asking who doesn't have a party.
Do you want
I
to
misunderstood your question.
What?
No.
Okay, you raise your hand, you're attorney for Jerry. Jonathan. And I'll give Nicole, so Jonathan and Nicole, attorneys for Jerry. District attorney, I'll also take 2. District attorneys. Nobody wants to represent the state here, huh? I'll give Amanda 1 because she's not here. And
Well, are some of our roles gonna are we gonna be questioning ourselves? You know what I mean? Like, how will that work if I'm Officer Flagg and then I also volunteer to be the district attorney, am I gonna be questioning myself on the stand or?
No, I already have you.
Okay.
So no. So I'm looking for Jennifer, maybe, Stephanie.
Sure, why not?
What do you want?
What's left?
Okay, what's left? District attorney, probation officer, judge's clerk. Mrs. Cook wants to be the star witness. Come on.
I'll be Miss Cook.
Okay, Stephanie.
I'll be the PO,
You be the who?
probation officer.
Probation officer, Jennifer.
I'll be the clerk.
Laura, clerk. How many have you? 1, 2.
I think there's only about 10 or 11 people in the class, so
Okay, I got them all. So,
you may not be able to double up on both anywhere.
you know what? I'm giving Amanda, district attorney. Amanda, if you're listening, I'll send her an email. If she can't do it, I might have somebody else fill it. All right. So read the fact. The fact page only pertains to the hearing in which we get into the trial stuff. Okay? And obviously this exercise is designed to sort of hit home what it was like, before. What kind of rights are afforded, kids today that are similar to adults in terms of due process. Okay, so that's what we're doing Thursday. Any questions? And really, don't be afraid to get into the roles, okay? Jerry's, for example, who's Jerry's brother? Joe?
Yeah.
And then, oh, I don't have a Jerry's brother. That's okay, because I wouldn't need one for the hearings afterwards. So Joe, you can be really pissed off I'm sorry, I'm saying Joe and I'm looking at Jim. See, there's too many
No,
J's.
Mike.
Joe, oh my God,
Jim's over
Jim, Joe, Jonathan,
You're gonna go cross-eyed if you're looking at Joe and Jim at the same time.
Jonathan, Joe, Mike. Jonathan, Joe, Mike, and then Jim's over there, okay. But anyway,
So you're
whoever
saying- You were saying about the
represents.
brother? You were saying,
What?
you were talking about the brother, because I'm gonna be the brother in the first.
Yeah, so you know, you can be really pissed off at him. Same thing, I mean, Laura, you could be, you know, the mom that's really upset, you could be angry at him, whatever you decide, you know, just assume the role and stick with it, all right? No questions, all right then. So we'll do this on Thursday, okay?
You like my friend's child.